Hello, everyone, and welcome to our July Worldview webinar. My name is John Baker, and I'm the Chief Marketing Officer at LCR Capital Partners. Today, we are going to have a broad-ranging discussion about the state of the program. To say we've had an eventful few weeks is an understatement. I think in the history of EB-5, the week of June 22nd to the 30th will definitely be one to be remembered. We had the Bering court case that reset the regulations back to before the November 2019 modernization, and the effort to pass the Grassley-Leahy bill by unanimous consent in the Senate was blocked. And of course, the sunset date of June 30th has passed, which has caused a lapse in the program. That is a lot for our industry to work through and digest. We recognize this is a very confusing time for clients. LCR works hard to communicate and educate as much as we can. We do webinars like this one. We have our teams in the markets ready to talk to clients or to investors who have questions. And of course, we also post blog posts on our site and in social, promote the great work that's being done by other members of the industry. That said, a lot of what we're talking about today is outside of LCR's control. And so we ask that you work with us. We're happy to share what we're doing, what we believe could happen. But despite all the work we've put in, it's a difficult time for all of us. That said, we remain optimistic that the program will be reauthorized and believe that the bills, which are still in the House and in the Senate, are improvements in the program. And in time, our hope is that we'll look back at this summer as, yes, a time of frustration and a time of delay, but not one that stopped our goal of helping people move to the US. And for you all, who are investors and clients, to actually achieve your residency and begin your life in the US as permanent residents. So a couple of housekeeping points about the webinar. We are recording today's session. We will make the video available on our site after we're finished, as we always do. The second, we expect quite a few questions. We understand there's a lot of frustration and confusion about what it means for individuals. We ask you use the Q&A button. This is on the Zoom software at the bottom of your screen. It's the easiest way for us to manage it. I would also say, as much as possible, if you could ask more general questions rather than individual ones. I will be reading a disclaimer in a bit, but obviously we can't engage in immigration legal advice on a webinar at the individual level. You need to talk with your individual immigration attorney. So if you can try to keep your questions at a more generic level, that'll help us be able to answer them and also be useful to the broader community that's watching. With that, let me introduce our panel. Ron, would you like to start and give a quick background? It's great to have you back in an LCR webinar.
Sure, thank you, John. Hello, everybody. I'm Ron Klasko. I'm the chairman of the Klasko Immigration Law Partners law firm. My relevant background is I served 5 years as the EB-5 committee chairman of the American Immigration Lawyers Association. I chaired the best practices committee of IIUSA, and I head up the investor practice at our firm, which is one of the largest EB-5 practices in the country, representing investors, NCEs, regional centers, and getting involved when projects go bad and trying to make everything work for everybody. So that's a little bit about my background, and thanks for inviting me, John.
Pleasure. Aaron, we've had the good luck to work together on a few things. Could you give a quick introduction and perhaps a quick introduction for IIUSA in case anyone isn't familiar with it?
Of course, and thank you very much. My name is Aaron Grau. I am the Executive Director of Invest in the USA, or IIUSA. IIUSA is the national not-for-profit trade association representing the EB-5 ecosystem. We have 250 plus membership organizations in the United States, as well as partnerships around the world. My role at IIUSA, sort of in addition to making sure that the trains are running on time, is an opportunity to work very close with our lobbyists and our public relations team as an advocate for the program. So I'm grateful to be here and grateful that you're welcoming IIUSA's perspective. So thank you, John.
My pleasure. So Matt, you're a member of the LCR team. Could you give a quick overview of your role at LCR and your background in working with the Senate?
Sure. Thanks, John. Yes, my name is Matt Virkstis. I'm the General Counsel and Chief Compliance Officer for LCR Capital Partners. I joined the firm in about 2017, end of 2017. Very pleased to be with you all today, and especially with Ron and Aaron, two very important voices in the industry. By way of background, prior to joining LCR, I spent about 9 years working for the U.S. Senate Judiciary Committee and had a fairly diverse portfolio, but immigration was one of the issues I handled for the time that I was there, and that obviously included EB-5. So I have my experience with EB-5 is largely on the policy side. In recent years, it's been more on the practice side, the business side of things, but I got to know the program relatively well and worked with folks in the agency and in the Senate and in the House over those years to try to help the program along, to make it more efficient, to address issues that stakeholders were experiencing with adjudications and such. So I've watched the program grow from 2005 when I started in the Senate to a relatively little known and undersubscribed program to what it is today. And like John mentioned at the top, I certainly share his optimism that we'll see the Congress do the right thing and get the program reauthorized, but also clear-eyed about the fact that we're in a very sort of uncertain time, and we at LCR, and I think elsewhere in the industry, everybody recognizes that there's a lot of angst at the moment given the uncertainties.
Thank you, Matt. It is true. But again, the optimism helps us make it through this period. So before we dive in, a couple of disclaimers. Obviously, the EB-5 visa is based on an investment, but this marketing presentation doesn't constitute an offer to sell securities. If you are interested in seeing project investment documents, we ask you to contact LCR directly so we can confirm you are an accredited investor or the equivalent in your market. We also then can focus the conversation on your individual or family needs. The second, while we're discussing areas of immigration law, and we expect a number of questions on that side, none of the conversation or QA can be considered legal advice. You will need to reach out to your attorney directly or enter into a client-attorney relationship to receive legal advice. And again, we do recognize that there are a number of questions about what the lapse means for you specifically, and we have reserved a section just right after we dive into some of the questions to go through the EB-5 application process and talk about what the current guidance indicates for people at each stage of that process. But before we jump in, because not everyone on the webinar will be completely current, Matt, let's take a second and talk about these last 2 weeks, or this week that occurred at the end of June. The two big events I mentioned at the top, the Baring case and the sunset date. Let's start with the court case. If you could just summarize what occurred with the judge's ruling on June 22nd and what the implication is for people who aren't familiar with it.
Sure, John, I'd be happy to. And Ron and Aaron, please chime in if I leave anything out or if I miss a point that's material to the summary here on any of these topics. So the Baring case was brought by, I believe, a regional center that was challenging the regulations that were finalized by the Department of Homeland Security and the Office of Management and Budget in November, and I think they became effective November 20th of 2019, if I'm remembering correctly. Those regulations, as everybody knows, did a number of things to program in terms of program policy. The most meaningful, probably from a market perspective, was the increase in the minimum investment amount from $500,000 to $900,000. So it was significant. Up until the point that those regulations were implemented, DHS and the DHS's predecessor agency, the INS, and then subsequently DHS and its sub-agency USCIS, never adjusted the minimum investment amount, even though they had the authority to do so under the statute and public law that govern the EB-5 programs. Those regulations were challenged. In a nutshell, they were challenged for a number of different deficiencies or claimed deficiencies. The one that stuck and the one that the judge decided the case on was a violation of the Vacancies Act. And in plain language, I think the best way to describe that is to say that the person responsible, the acting Homeland Security Secretary at the time that the regulations were finalized and published in final form, did not have sufficient authority to do so, to take that action. And the reason being that the Department of Homeland Security Secretary at that point was in an acting capacity, or maybe even something less than an acting capacity. But suffice to say, the court was not, the court found it determinative that given the status of the Department of Homeland Security Secretary at that time, that the regulations were not effectively finalized at that point because there was a lack of authority under the Vacancies Act. So the court decided the case on that issue alone and dismissed the other claims in the original complaint. So what the judge did was to set aside those regulations. So in other words, make them ineffective and remand the rule back to the Department of Homeland Security. My basic understanding, and Aaron and Ron, please chime in, but my basic understanding is that going forward, the judge rejected claims by the US government that Secretary Mayorkas's ratification or attempted ratification of the prior rule was effective to keep it alive and to overcome the Vacancies Act issue. So that was rejected. And from what I understand, the secretary will need to redo the Administrative Procedures Act process if the department wants to reinstate the November 2019 rule.
Unless there's an appeal and unless the circuit court says otherwise, yeah.
That's, yes, an important point. That's right. And Ron, do we know whether or not the government has decided to appeal this?
I do not know that one way or the other.
Yes, I haven't seen anything on that, so I don't know where the government stands on that particular.
I don't think it's a certain. A lot of people think they'll certainly appeal. If I were counseling the government, I would not appeal that case for a whole number of reasons that we can talk about. But at this point, I don't think we know for sure.
Okay.
And I think as we run through the webinar, we'll talk about that a bit more, because this obviously the two big parts of the 2019 regulations, the resetting of the investment level and the way that TEAs were designated at the state level versus the federal level. Currently, the regulations in place for the EB-5 program overall are the pre-2019 rules, so before those changes. The second piece, Matt, of course, is the sunset date, and we'll talk about that quite a bit, but just do a quick summary of what happened legislatively that produced the June 30th date and the implication.
Sure. So as people are probably generally aware, the EB-5 Regional Center Program is a pilot program. It was enacted as a pilot program a couple of years after the base EB-5 Direct Investment Program was put into the Immigration and Nationality Act of 1990. In 1992, Congress passed a series of appropriations bills, one of which was the Commerce, Justice, State Department, and Science Appropriations Bill, Subcommittee Bill, which provided federal funding to the Justice Department, the State Department, the Commerce Department, et cetera, to certain functions of the executive branch. Proponents of the EB-5 program at the time, Senator Simon and others, I think, were successful in including a pilot program to, as I've read the legislative history on this, to spur greater interest in an immigration investment program in the U.S. In 1990, I think the original program did not attract a lot of interest, and so the 1992 Regional Center Program, which permitted the counting of indirect jobs and pooling investments, was intended to give a little bit of a jump start to the concept of investment immigration in the U.S. The result is that the EB-5 Regional Center program was never made permanent. It has resided in a public law, which is this 1993 appropriations bill for years. It has never been codified into the INA, although I think bills, including Senator Grassley and Senator Leahy's bill, may have a section that puts the Regional Center program into the INA where the rest of the EB-5 program lives. That's sort of a technical issue. The important piece about that is that the EB-5 Regional Center program, which is the vast majority of investment through EB-5 comes in, was created as a pilot program, and from 1993 until the present, it was reauthorized for varying periods of time and never made permanent. There was a standalone legislative reauthorization that went from 2012 to 15 that extended the EB-5 Regional Center program and a few other immigration programs that were of a temporary nature. Since 2015, the program has been reauthorized in 6 months to a year periods in the government spending legislation. So whether that government spending legislation can take several forms, either an omnibus appropriations bill, which includes all of the funding bills for the federal government, separate appropriations bills, which are far less common these days, or continuing resolutions, which are just small bills that continue the spending authority that Congress gives to the executive branch. What happened was that the most recent sunset date was June 30th of 2021. As we've discussed on prior webinars, the reason that June 30th date, the reason that the expiration date fell on June 30th as opposed to September 30th was that the EB-5 program was removed, or at least that date was decoupled from the most recent omnibus spending bill. So it created a bit of an orphan of the EB-5 program, because historically the EB-5 program had traveled with 3 other immigration extenders, and they had been synced up and traveled in tandem in terms of their authorization periods. We, as people may have observed, we got to mid to late June, and there were discussions. I know Aaron can speak to this better than I can. Furious discussions going on about how this was going to be reauthorized. There was not agreement on a clean reauthorization. So in other words, just extending the date either to September 30th or some date farther out in the future. Senator Leahy and Senator Grassley had introduced a bill earlier in this session of the Senate, which would have reauthorized the program for 5 years and would have made a number of other significant substantive changes to the program, mostly relating to reporting requirements and oversight of regional centers, investor protections, et cetera. Long story short, the members, Senator Cornyn, Senator Grassley, and Senator Leahy, went down to the Senate floor to ask for a unanimous consent. So in other words, the agreement of all 100 senators to take up and pass their reauthorization legislation. Senator Graham was on the floor at the same time and objected to their motion to take up and pass the Grassley-Leahy bill. I don't believe, looking at the record, that any explanation by Senator Graham was given about why he objected to reauthorizing the program, but he's not obligated to. So that's the procedurally where we are right now. So the program, as everybody knows, is without an authorization. That's how we got to this place. And let me stop there.
Aaron, would you want to add anything in terms of the lapse? Just quickly.
No, I mean, that's Matt hit everything. Very good summarization of what happened and where we are and why we are where we are.
So I want to make sure that we're answering questions that we've seen come across in email and come across in phone call conversations with our team around individual investors at the different states of the process. So if we can run through that, then Aaron, I'd like to come back and talk about the reauthorization process and what's happening in terms of advocacy and the political activity in order to get reauthorization. But first, let's take a look at individual investors. We all are very familiar with the EB-5 application process. This is, again, the regional center process. And so I'd like to just step through it and ask Ron and Matt, or Ron primarily, what it means for the investor. So obviously, if you filed your I-526 petition before June 30th, before the lapse, if you are in the rush and you haven't gotten a receipt, should you expect to get a receipt of
Short
your
answer
file?
is yes. Yeah, your 526 that was filed by June 30 should remain pending. And since it remains pending, it should result in a receipt notice being issued. John, before we get too far, you mentioned the regional center program. Just so everyone listening understands, nothing we're talking about on the reauthorization issue relates to direct EB-5s. So the direct EB-5 program is a permanent program, and it continues without any changes. What we're talking about on the $500,000 investment amount does apply both to regional centers and direct EB-5. So just wanted to make that clear.
Yep.
That's a great point.
And thank you. So the next step of the process, you've filed your I-526, you've received your receipt, but you haven't been approved. We've had guidance pretty clearly that those will not be reviewed. Correct, Ron?
Yeah, that is correct. So it seems very clear that their position is, and I think it's probably correct, that they shouldn't return the 526s. They should keep them pending. They have no authority to approve them because they'd be approving something under a program that doesn't exist when they're approving it. So it should just remain pending. It goes in a drawer for 2 weeks, 2 months, whatever it's going to take for reauthorization. Then you have also the issue of the I-485. So what if you have an approved I-526 and you've applied for adjustment of status? Same thing should apply. If your I-485 is already filed, it should remain pending. You should get a receipt. Well, will I get advanced parole and employment authorization? The answer to that should be yes. If the 485 is pending, all of the benefits that go with the 485 should continue. And we have that in writing from the government in at least 2 or 3 mandamus cases that our firm has filed. And we know other attorneys also. So the government has stated to the courts they will continue to issue EADs and APs. They will not accept new I-526 filings because the program doesn't exist. They will not accept new I-485 filings because the I-526 that's approved is approved based on a program that doesn't exist as of today. So the ability to file for adjustment based on that doesn't exist. So they will reject new I-485 filings. And of course, if the new I-485 filing is accompanied by an EAD and AP request, advanced parole and employment document request, they will also reject a new one. So there's a difference between pending 485s, which should continue to get benefits, but won't be adjudicated, and new 485s, which will not be accepted.
And of course, for people outside the United States, no consular interviews will be granted.
Correct. So just like the Immigration Service will not be authorized to do anything on pending cases, the State Department and the U.S. consuls will not be authorized to do anything on pending cases, and that includes, going ahead with scheduling interviews.
So there's obviously a couple steps before the interviews, or even at times the adjustment of status. It's the biometrics and things like that. I mean, do we expect the agency to continue to schedule biometric appointments, or would you expect those also to not go forward?
I don't know the answer. I think if they think about it, they won't schedule it, because why do biometrics on a program that doesn't exist when the biometrics may expire by the time the program's reauthorized? whether they think about that, because there's an independent contractor involved with biometrics, and whether they instruct the, that the biometrics, now, I don't know the answer to that. But I think it would make sense that they wouldn't go ahead with biometrics.
Right. And of course, then you get to the stage which has some good news, that you've received your conditional green card and you're working through the 2 years and you're looking to apply for the removal of the conditions. All of those go forward as normal. That's part of the broader program.
Yeah, so that's we talked about the good news that what we're talking about doesn't apply to direct EB-5s. They go forward as normal. Also, if you are a conditional resident, as of June 30, none of this applies to you, and you can continue to file your 829. Pending I-829 can be adjudicated, and just using logic, which is often a mistake in this field, but the Immigration Service now has a large cadre of examiners, adjudicators, who can't be working on 526s, can't be working on I-924s for regional centers, can't be working on adjustments of pending I-520, of approved I-526s. And unless you're going to put them in a corner and say, just sit there and don't do anything, you've got to reassign them to something. The most logical thing to reassign them to would presumably be direct EB-5s and I-829s. So it's certainly possible that I-829 adjudication times, which are now often 3-4 years or more, could shorten if they do what I think is the logical thing with the examiners that aren't doing other things.
Well, I know, Matt, that would be welcome news for our clients to see the group that have their conditional green cards being processed more quickly.
Indeed.
So, Aaron, let's shift back to the legislative advocacy. We all want to be, we all want to see this program reauthorized. And I know you're also optimistic. What makes you optimistic? What makes you believe that Congress wants to reauthorize the program?
Well, I look at what the EB-5 community has been able to accomplish thus far. A bipartisan negotiated bill, S-831, that has the support not only of Grassley and Leahy, but also Senator Coons from Delaware. And we saw Senator Cornyn from Texas go to the floor and ask for unanimous consent along with his colleagues from Iowa and Vermont. That's pretty significant in and of itself. But when you add to that the mirror legislation, the companion bill that's been introduced in the House by Representative Fitzpatrick from Philadelphia and Representative Stanton from Arizona, again, bipartisan, Stanton actually being a member of the House Judiciary Committee, you really begin to shore up the foundation of support for the reauthorization writ large. And if you take a look at the House bill, it's the exact same verbatim language that was introduced in the Senate. And in addition to that, the swath of bipartisan co-sponsors there is growing. I mean, I think we're at now 25 House members have co-sponsored the bill. And they range from very progressive Democrats to very conservative Republicans. And everybody in between recognizing the value of the program and what it does for the country, what it does for communities, and what it does for immigrant investors. And so I remain optimistic because there was one sole objection offered on the Senate floor. It came practically, if not literally, at the finish line. It was a surprise. It was unfortunate. There were not really many, if any, reasons given for the objection, which leads me to believe that in many ways it may have been political, although I have no firsthand information. And our hope is that as we re-engage with Senate staff and with House staff, that those political hurdles can be addressed and we can get this done.
So one route then towards reauthorization is that effectively there's a negotiation. And is it then an amendment to the Grassley-Leahy bill and it's put forward again for unanimous consent? Is that one route you see?
That is one route. IIUSA believes strongly that just given the amount of bipartisan bicameral support that the two bills have, that the Grassley-Leahy, I'll go out on a limb. I'll say Grassley-Leahy, Cornyn, Coons. That might be a bit of a stretch, but that bill should be the basis for any further negotiations, and that any changes to the bill that would help appease any objections would be addressed within the four corners of that piece of legislation. After that, another unanimous consent and presumably similar process on the House side is certainly a possibility. There are other avenues as well. We do have an infrastructure bill that's being debated, and that may be a vehicle for us to take a look at. But certainly unanimous consent is something that's very viable, and if not required, given the time constraints that we have with congressional summer recess, et cetera, et cetera. And to that end, I would simply make this point as a bit of a added response, that the EB-5 community needs to pay attention to Senator Grassley and Senator Leahy and the work that they put into developing this bill. If their legislation is watered down or amended too much, you may simply end up, especially in unanimous consent scenario, you may simply end up substituting Senator Grassley for Senator Graham as someone who would oppose the bill. So it will be a delicate balance, but IIUSA has certainly built up some goodwill with Senators Grassley and Leahy, and we look forward to all others at the table as well to make sure this happens.
Yeah, I know that we've talked a lot, Matt. We're very supportive of the bill. You know, the additional reporting is reporting that we sort of expect to do as a very professional regional center, and equally we do background checks, and we would love to see the improved processing times, obviously. So the negotiations now, I know that you have a standing working group. Does that bring in other members of the EB-5 industry? And is it working directly with the staff, including, for example, Senator Graham's staff?
We want to work with Senator Graham's staff. And furthermore, we'd like for the conversations to include this go around House Judiciary Committee staff. The first time we were very focused on negotiating the text of the bill. And we had the understanding, appropriately so, we feel, that as things went in the Senate, so things would flow in the House. But I do think it's important to bring the House staff members into the conversation as well. We're waiting to have a meeting scheduled, hopefully this week, Thursday or Friday, to begin that process with Senator Schumer's staff. He'll obviously play a huge role in pushing this over the finish line.
So Matt, one of the questions that we've had here is, you know, would the investment level be changed through legislation, not through regulation, which is what happened in 2019. But instead, you know, that's the kind of an amendment that could go into a revised bill that then could be put forward through unanimous consent or attached to an infrastructure bill. Is that accurate?
Sure. As a practical matter, a legislative matter, this, you know, the Senate or the House, depending if, you know, if they have enough agreement, could do whatever they wanted to in terms of amending Leahy's and Grassley's bill prior to it being attached to some other piece of moving legislation. There's really no limitation on what the Senate and House could do legislatively in terms of, you know, tweaking, amending, changing, revising the existing introduced legislation. You know, until such time as it's enrolled in the House and Senate, it can be changed.
And then the constraint on that is, as Aaron mentioned, whether Senators Grassley and Leahy would accept too much change to the bill that they've worked on. Yeah,
exactly. That's right.
So there's a second question here to you, Aaron, saying finding common ground. I think you've addressed that, and I think, I mean, is it fair to say that the fact that there are so many investors pending, that's one of the drivers of the activity in Congress? They don't want to see whether it's litigation or, the reputational effects of seeing those investors not having an avenue towards completing their immigration goal?
I certainly hope so. I think there would be a real morality check among any members or staff who didn't recognize investors' position. So I do think that it is. I think they are not ignorant to what is to come or what could happen if the reauthorization doesn't take place, let's say before the end of the fiscal year in September. That's a big reason why overall IIUSA is taking a very pragmatic approach. I mean, we are very interested in compromise. We're very interested in doing the most amount of good for the most number of people, with the recognition that as long as we get what we need to continue the program, that we are not going to get everything we want. That's the nature of this process. But above all, I mean, we want everybody to recognize, John, what you just pointed out, that the option of not reauthorizing or not reauthorizing before long does create some pretty significant hurdles, not only for investors but also for regional centers and the developments that they're promoting. So hopefully everybody does recognize that fact.
And just to be clear, our understanding is that the USCIS wouldn't reject any applications unless there was a clear statement by Congress that the program was not to be reauthorized. Ron, is that your understanding as well?
Well, all right. So, John, it's really important because there's been some confusion on this, the term reject versus the term deny. So the Immigration Service said they will reject any new 526s or new 485s based on 526s. Reject means not accept for filing. Once it's filed, there is no such thing as rejection. It's already been accepted. So then the question is, are they going to let it sit? Yes. Are they going to approve it? No, until it's reauthorized. Are they going to deny it? Well, at this point, we hope the answer is no. And I think the Immigration Service expects the answer is no. Now, in the very unlikely event that we're sitting here a year from now and the program isn't reauthorized, I don't think anybody thinks that's possible. But if that were the case, at some point, it is certainly possible they could say, well, we're not just going to keep these forever and we'll deny them because there is no program. I don't want to put any emphasis on that at all, because I think that's incredibly unlikely. And we can debate whether the program is going to be reauthorized in July or August or September, which is a fair debate, but I think it's almost undebatable that the program at some point will get reauthorized.
Right.
John, if I could just add to Ron's point a little bit, that's a really an important point to make. I think one of the things that everybody should keep in mind, and I'm looking at a question here in the Q&A about how many times the EB-5 program has lapsed. If my memory serves correctly, I think it's lapsed twice on just because of statutory lapse, because the time, the date was passed without action by Congress, and then maybe once due to a government shutdown. But in both cases, the USCIS has approached the lapse generally the same way. First, the agency in past occasions has assumed that Congress will reauthorize the program and have taken steps, as Ron was describing, to essentially hold pending petitions in abeyance. They're not sending them back. They're just not working on them because they don't have the authorization. But they're doing that. They're not going to the extreme and sending things back because their assumption is, and has been at least historically, that the Congress will reauthorize. I think one thing to keep in perspective in the current situation is that, well, a couple things. One is that in the US Senate, 99 senators were prepared to move forward on the Leahy-Grassley legislation. One senator said no. What reason? Who knows what that senator's he was representing, whose views he was representing. In any event, from a statistical perspective, it's not a big percentage of the views of the U.S. Senate. Furthermore, I think it's not representative of a prevailing view among the industry as it relates to the the Leahy and Grassley bill. Nothing's ever going to be perfect. It never is legislatively. So I think that, to keep in mind the amount of support as opposed to the amount of objection in the U.S. Senate was overwhelmingly in the support column. So I think that bodes really well. I think the other thing to keep in mind is that the arguments here, at least as I understand them in the House and Senate, are not about whether to keep or discard the EB-5 Regional Center program. The debates are over sort of smaller policy-related issues that are preventing moving forward. And so I think to the extent that the agency is aware of the political and legislative dynamic, I would hazard a guess that the agency probably is proceeding as it has in the past on the assumption that Congress will, at some point, hopefully in the near future, reauthorize the program. Because there really is there's no support that I can glean in the US Senate or the House of Representatives to do away with the program.
Yep. And Aaron, you see that as well in your conversations.
I do. I believe even Senator Graham, who was the senator who objected to the bill, recognizes the value of the program and has ideas insofar as what he needs to see. So I agree 100%. The program is valuable, and everybody recognizes that.
Yep. So let's turn to another question that we've had quite a lot, which is around the timing of reauthorization and changing in regulations, what's been called the $500,000 window, because given the reversal of the regulations on June 22nd and the program being authorized until June 30th, there were a group of investors who were able to invest under the old regulations, including with LCR, at $500,000. Ron, can you talk through the scenarios that this $500,000 window would reopen?
Sure. So let's start by saying that no one knows for sure at this point what's going to happen first and what's going to happen second. We all expect the program will be reauthorized at some point. We all expect the investment amount will go up again at some point. What we don't know is which will be first and which will be second. So for example, if the program is reauthorized before action is taken to increase the investment amount, there will be a window, the day of the reauthorization, for people to file at $500,000. If the investment amount goes up before the reauthorization, other than direct EB-5s, there'll be no window. So let's talk about the three different ways that could result in the investment amount going up. Number one, the investment amount could go up by legislation. So as part of the reauthorization legislation, Congress could say the same amount as was in the reg, the 901.8 million, or any different amount they want to say, and whatever definition of targeted employment area they want to have that would supersede, now that there is no TEA definition, or now that we're back to the 2019 definition of TEA. So that could be in the legislation. Some of us fear that the most important thing right now is getting this thing reauthorized, and starting to get into new debates on investment amount and targeted employment area definitions could only delay the reauthorization. So that's a possibility. If that happens by legislation, then it will be prospective only. So it would not affect anybody who filed, let's say, before June 30th, the $500,000 investment amount would not be impacted. The legislation would have prospective effect only. That's option one. Option two is the Immigration Service issues a new regulation to increase the investment amount, either right back to 901.8, basically reinstating the November 2019 reg, or anything else they want to do. I think it is most likely that they will at some point issue a new regulation that will have immediate effect, what they call an interim final regulation, that will reinstate the November 2019 regulation. I do not expect they're going to re-debate those issues. I do not expect they're going to do a new period of public comment. I do expect that there will be a lot of issues within the administration, because in order to issue a regulation, it goes through countless levels of bureaucracy that in normal times is defined at best by months and sometimes by years. So whether they are able to short circuit all of that and waive various levels of review and issue a regulation, I don't know. And then if they do it, then the question that some of us were discussing before we got on the air is, well, can a regulation be issued to involving a program that doesn't exist right now? And I believe the answer is that they really can't issue the new regulation on the investment amount until after the program is reauthorized. And so if that's the case, then there could be a window, potentially a very short window, between the date of reauthorization and the date of the regulation. Now, the next question is, if they issue a new regulation, will it have a retroactive effect or only prospective effect? And in my opinion, it would have only prospective effect. So it would not change the fact that what the court has said right now is the November 2019 regulation never existed. It was never proper, it never existed. I do not believe that USCIS has the ability to say, okay, we're issuing a regulation and we're saying it's effective retroactively to November of 19. They'd be challenged in court and probably lose if they did that. I don't expect that. So if the program, if the 500,000 amount is increased by regulation, it would be prospective only. Option three is that the government appeals the decision of the Northern District of California Federal Court that invalidated the regulation. In a second, I'll explain why I'm not so sure that's going to happen, but it could. If it does, then the government will request the Ninth Circuit Court of Appeals to issue a stay of the district court's ruling. What does that mean? That means they'll say, all right, we're appealing. We don't know what the court's going to say on appeal, but until the court makes a decision, we want you to eliminate the impact of the federal court decision. If that happened, then immediately we go back to the November 2019 regulation. I don't think that the circuit court would do that, but they have the authority to if they want. So let's assume they don't do that. And now we're waiting for the Ninth Circuit Court of Appeals to issue a decision about whether the district court was correct. That is not something that is going to happen in days or weeks. And that could certainly take 6 months or more after the government files an appeal until there is a court decision, and maybe sometimes a lot more than 6 months. So then there's two possibilities. One is that the Court of Appeals says the district court is right. Well, then we're back to where we are today, which is the November 2019 regulation is invalid and the investment amount is 500,000. Where it gets complicated is if the Ninth Circuit Court of Appeals says that the district court was wrong and the regulation was always valid. Why that's complicated is because that would presumably have retroactive effect. That would be saying the investment amount has always been 900,000. Anything the lower court said was wrong, and therefore anybody who invested at 500,000 is not approvable. I don't have any inside information on this, but I will. And I can tell you that, shocking as it may be, the government has not sought my counsel on what to do. However, I will tell you what I would, if I were general counsel of the Immigration Service, I would say do not appeal this thing for a number of reasons. Number one, there has been, I'd say about 10 cases in federal court challenging the appointments of DHS Secretary McAleenan, DHS Secretary Wolf, and Immigration Service Director Cuccinelli under the Federal Vacancies Reform Act. for improper appointments by the Trump administration. All of the challenges have been successful. So but none of them have been appealed. And if they haven't appealed the others, they may not appeal this one. And what they don't want is a higher court saying, yeah, all these lower courts are right. Then there's numerous challenges on all sorts of immigration stuff that could be made that haven't even been made yet. So it's a very high risk venture for the government. And then as a practical matter, does the Biden administration, it's one thing for the Biden administration to defend a pending case, which they kind of have to do. It's another thing for the Biden administration to make a filing in court on a new appeal and say, we think Trump did everything perfectly properly in all of his appointments. I am not 100% sure they want to go there. And for all of those reasons, my guess is they won't appeal. And if they appeal, they may well lose. So that's what people need to know about the prospects for the investment amount being changed by legislation, regulation, or court decision.
So let me just try to translate that a little bit again. And it's fantastic, Ron, and thank you for sharing and demonstrating a depth of understanding in this area. So the first one, we've had a lot of questions saying, I filed at 500,000. What's the likelihood that I'll have to add 400,000? That only happens in the scenario where, say, the court case is overturned and it's the retroactive case you mentioned. So very unlikely.
Yes, correct.
If the scenario where there's the opportunity for a short period to invest at 500,000 is where there's reauthorization or extension of the regional center program before the question of the regulations is solved. So an extension, for example, would open up a window, and because an extension would be based on the current legislation and the current regulation, which is pre-November 20. Yeah.
And investors may want to, given that that's a real possibility, but maybe a short-term possibility, investors may well want to be working with their attorneys to be prepared to file immediately if that window opens up at 500,000.
Which is effectively what happened in that week and caught us a bit by surprise. And we were following the court case, but we didn't expect there to be 1 week so close to the sunset date where you would be able to file. And Aaron, in your conversations, are you seeing discussion about extensions? And I mean, and it should be said that also the Grassley-Leahy bill doesn't address investment level. So if the Grassley-Leahy bill in its current form were to be approved, that would create a 500K window.
Am I seeing conversations about extensions? There's a lot of talk about extensions, but there's been no commitment that I've seen that would allow a clean extension to take place. The reason for that, I think, goes back to the stage that Matt helped set early on, back at the end of 2020, there was a concerted effort, presumably a well understood concerted effort and decision to decouple the program from the appropriations cycle and set it aside in an effort to address the integrity issues that are at play in the bill, as well as to give strong consideration to a longer term reauthorization. And it begs the, for certain members of Congress and their staff, a short-term extension or placing it back on the appropriation cycle begs the question that if we are to do that, why the heck did we bother decoupling it to begin with? Now, naturally, a lot has happened between then and now. We're faced with a little bit of a different set of circumstances. And so it's possible that the conversation around an extension will pick up a bit more validity. However, there is also a lack of appetite. I feel, this is my personal feeling or observation, there is a lack of an appetite to kick the can again. There's much more of an appetite to create a long-term extension, long-term reauthorization to provide some stability rather than revisiting all of these conversations again in September. So that's probably a long-winded way of answering your question. I could have just said yes, but there are a lot of qualifiers to what that conversation actually sounds like.
Yeah, it's a difficult environment, and I think everyone who's worked in industries based on government regulation and legislation expect a degree of this, because both the agencies and the Congress can make changes, and the industry has to react. But it is very frustrating to not be able to answer definitively to people. We've seen a number of questions here concerning specific travel rights or specific scenarios. Actually, one question that did come up that we didn't know the answer to, but and Ron, this one you might know a quick answer to, which is obviously people have children that were under 21 when they filed, and their age is being held. I guess it has to be assumed that all of that holding of their children's age in terms of their immigration benefit would stay the same unless something happens and the filing is returned. Is that accurate?
Yes, under the Child Status Protection Act, as long as the petition is pending, the child's age is frozen. And as long as the Immigration Service does what I'm saying they're going to do, which is just hold the case pending, then the child's age remains frozen for a longer period of time. So for those people who have situations with potentially aging out children, this is actually a good thing, because it will keep the child's age frozen for a longer period of time.
So, and we recognize that each of you listening likely have, for those of you who have invested, have personal stories and personal scenarios. We highly recommend you consult with your immigration attorney, because it is difficult for us to answer those specific questions. I think, as we approach the top of the hour, I would say, first of all, we are optimistic that the program will be reauthorized. And for that reason, we haven't been addressing and even gone in to look at what the implications of a non-reauthorization would be for our investors in terms of their capital invested. The second thing I would say is we still believe, because there's the potential for 500,000 or returning to 900,000, LCR is working with our development partners to make both options available, just because we can see that scenario occurring. And then the last one question was, is LCR in a good position even with the lapse? And the answer is yes. We're maintaining all of our teams. We're maintaining our efforts with Aaron and IIUSA and working closely with partners like Ron in order to both push advocacy and take care of our clients and investors, because we understand that it's a difficult time, and we're doing everything we can to communicate as openly and transparently as we can as we go through this period. Any closing thoughts, gentlemen? Matt, would you like to have a closing thought, and then we'll finish up?
Yeah, I'll try to be brief. I mean, I think this has been a terrific discussion. I would commend anybody on the line to visit Ron and his team at Klasko Immigration Law Partners. Put out a terrific blog post that's an FAQ about various scenarios that were discussed today, but it's very clear and easy to understand, and I think asks all the right questions. Additionally, IIUSA is a terrific source of news and insight and industry activity, so we would commend people to the association's website as well. I mean, I think it's obviously a really challenging time. It's an extremely challenging time for folks who have pending petitions and who are caught up in with the effects and the consequences of this lapse in particular. I think, keep in mind that, I take heart personally in the fact that members of Congress who care about this program understand the implications of just letting it lapse indefinitely. And I think they recognize that those consequences are not tenable from a diplomatic and government administrative type of perspective. So I don't, again, just to reiterate, I'm very optimistic the program will be reauthorized. I think the challenge is trying to crystal ball the way in which that's going to happen, because things can be very unpredictable in the Congress. They can happen quickly. They can take longer than you'd like. There's a recess coming up here, district work period for the members, for their summer recess time. And so the calendar is relatively truncated at the moment. But I think it's going to be reauthorized. That's my personal view, my personal prediction, and I think it's probably shared by the majority of folks in the industry. So, as challenging as this is, and as not only inconvenient but very disruptive and unsettling, I think that the government is aware of that. The Senate and House are aware of that, and we will see some reauthorization at some point, and hopefully the agency will do the right thing in terms of continuing to put out guidance to all stakeholders, but most particularly the people who are the customers of our immigration agency, and who deserve a clear message from the agency about what it's going to do and what people can expect.
Ron?
Thank you, John.
So I would just make two quick points in closing, in addition to the point of thanking you, John, for inviting me. Point number one is it's probably more important than ever that for investors who are interested, who view EB-5 as an option for them, it's more important than ever that they be working with their immigration attorney, because quick action may well be required at some point. So when all these events that we're talking about, investment amount, reauthorization, when it happens is not the time to start planning. You want to be able to act quickly, file something quickly once everything works its way out. The second point I'd make is it's more important than ever that the EB-5 industry, no matter where you are in the industry, make known to members of Congress how important the EB-5 program is, not only just to them, but to the country. I won't go through all the reasons with you, but we all know that it has done wondrous good things for our country, and Congress needs to know the horrible impact of the delay in reauthorization and God forbid the end of the program. And now's the time to let them know your opinions about that.
Thank you, Ron, and good advice. And I think advice Aaron would welcome. Aaron, you have the last word.
Thanks. Appreciate being on this call. Honored to be here with Ron and Matt. I have optimism as well. I always have. It's been a frustrating end to June, and yet a promising beginning to July. As I've said, we're anticipating conversations reigniting here shortly this week that we hope will take off very quickly, and that we may be able to see a reauthorization well before September. So we're hard at work. We're carrying a pragmatic attitude and looking forward to as much success for as many people as possible. So thank you very much, John.
Thank you, Aaron. And as we've said before, we're supporting you, and we'll do everything we can to keep the program moving and get reauthorization as fast as possible. Thank you very much, Ron. Thank you, Matt. And thank you all for listening and staying with us. As I said, we'll have a recording of this and we will send it out to everyone as soon as we can. Thank you very much, everyone, and have a good day.
Thanks, John. Thanks, Ron, Aaron. Good to see you guys. Bye-bye.